Hi, Jack Needham here, Associate Editor at The Daily Journal and your host of In the Counsel's Chair, a new podcast from The Daily Journal where we talk to legal leaders about how they shape their world and ours. In today's episode, we talk to John Nadolenco, Managing Partner of Mayer Brown's Los Angeles office and co-chair of the firm's Global Technology Industry Group. John talks career moves, leadership lessons, and major cases. Let's dive in. John Nadolenco, thank you so much for joining the Daily Journal. If you could just give us a brief overview of what you currently do and your practice area and how you got to your current position.
Well, thanks for having me. I know this was a new endeavor for you guys. I really look forward to working with you on this. Um, my background is somewhat simple from the litigation perspective. I joined Mayer Brown about 30 years ago, straight out of law school. I've kind of been here since. So that part is easy. I have focused my practice on class action defense kind of throughout that time. And I've also enjoyed having a number of managerial roles at Mayer Brown, starting, back as the office leader for the litigation department. Then I became one of the firm leaders for the litigation department. I sat on our partnership board for a while. That's kind of think of that as our board of directors. I currently sit on the management advisory board that works with our management committee to set strategy for the overall law firm, and I get to be the managing partner of the firm's Los Angeles office.
You mentioned primarily class action defense. I'm so curious how that happened. Did you exit law school being like, I just want to do class action defense. That's what I really want my career to look like. Was there a
Uh,
defining moment for you that became very apparent that was going to be the majority of your work?
yeah, gosh, I hope not. I definitely did not come out of law school thinking, class action defense is for me. What I did know, though, coming out of law school is I want to be a litigator. I want to be a trial lawyer. And so the way I kind of came into the class action world actually, goes all the way back to the Silicon Valley era when the dot-com companies started really a war on talent and uh, compensation in Silicon Valley was going up. Big law was trying to keep pace to keep their talent with associate increases. And what you ended up seeing is that big law was really focused on bigger type cases. And just, financially, that's where clients were going to start looking to the bigger law firms for. It wasn't going to be the cookie cutter, cases that we're going to get assigned to a big law firm. It was going to be more of the higher stakes cases. And so kind of, I don't know, my fifth or sixth year out of law school, I kind of made a business strategy decision. I was like, I think class actions are going to be a thing that stick around and that clients will go to big law firms for class action defense because they tend to be higher exposure cases, tend to be a little bit more as far as the company's attention to those. So it was purely a pragmatic business decision that I was like, I think this might be the wave of the future. So I just picked that lane and kind of have stayed in it since.
And I'm going to put you on the spot now because you've touched on something really interesting. If you were doing the same thing again right now, you're at the same point of your life, you were sort of trying to predict where the profession, where the money was sort of headed, what decision would you make? Is there a particular area of the law, area of defense you would sort of be gravitating towards? Is it the exact same decision you made back then?
No, I mean, in part for the type of litigation, I do still think it's class action defense. If I had to pick a subject matter right now, I mean, and I don't think I'm going to surprise you when I say this. Uh, AI is hot. And what I really mean by that, if I was a kid coming out of law school right now, I would figure out what the practice of law looks like with AI capabilities. I'm not a big believer. I don't think AI is going to, replace huge swaths of associates. I think, though, what associates and lawyers and partners, everyone's going to have to do is figure out what is AI excellent at and what isn't it good at, and how can we kind of work alongside AI going forward in the practice of law. So that's kind of what I would be focusing on. And it is actually what I am focusing on. So
I'm going to pick your brain one more time about the class actions, just because it seems, for someone slightly detached, it seems like the sheer volume of class actions over, say, the last decade and a half has just increased monumentally. I'm curious, is that the case? Have you seen over your career a big increase in the volume? And then just in terms of any legislative reaction to that, any sort of strategic defense reaction to that? I know there's sometimes efforts to limit the use of class actions and things like that. But what sort of general trends in the class action space have you observed over that time?
yeah,
How are
so
they
I,
changing?
I do think your instinct is correct. There's been a proliferation of class action cases over the course of my career, and what exactly they focus on, ebbs and flows. But I don't think it's any secret, and I'm, not being critical of my brethren on the other side of the B, but, from a plaintiff's lawyer's perspective, class actions can be potentially more lucrative. Instead of bringing a claim on behalf of one person, it's potentially hundreds, thousands, tens of thousands, hundreds of thousands of people. That could be more lucrative. And that's why I always, I thought it would be a higher stakes piece of litigation from the defense perspective. And so I do think you've seen a proliferation of those. One of the things I have always tried to do is, I don't treat any case as cookie cutter. It's not commodity work as far as I'm concerned. It's, everyone's unique, everyone presents new facts and new challenges. But we have looked for ways, at Mayor Brown certainly, to try to deal with and attack whole swaths of class action cases. One of the things I was involved with early in my career was trying to compel class action cases to arbitration, right? So Supreme Court decided, years ago, a famous case called the Concepcion case that allowed enforcement of a class action waiver in certain consumer agreements. And so that was one way for companies to basically get rid of, a lot of exposure in class actions through having them sent to arbitration. And I got to be part of, a relatively small part of the team that worked on that arbitration issue. Mayor Brown was, I think, one of the leaders in that overall effort. I was pretty junior in my career as a part of it. But what it taught me was to look at other ways to attack whole swaths of class actions. And kind of the cause I championed was trying to get rid of what I called the no injury class actions, ones where there is like a ticky-tack hyper technical violation of a law, but the law itself, for example, would have automatic statutory damages, and the exposure to the company could be absolutely staggering. It could annihilate a company out of existence, but like when you look at the other side, like there's actually no harm. And so that just struck me as monumentally unfair. And so, we kind of took it upon ourselves to fight those no injury class actions. Um, and would an example of kind of what I'm talking about be helpful, or?
We love examples. I was
All
going to
right.
list.
So, my favorite one that resonates, I think, the most with me was this FACTA class action. So FACTA was this federal law that at one point said that companies printing receipts should no longer print the credit card number or an expiration date on a receipt. Right. So nowadays, this. You get your receipt, you go out to eat, you get your receipt, or you go to a gas station, you get your receipt. It maybe has the last four digits in your credit card number. It doesn't have the expiration date of the credit card number anymore. But for a while, it took companies a good amount of time to catch up to this law. And what they did is a lot of companies really quickly got rid of the credit card number. They're like, yeah, get that off the receipt. But some of them still would print the expiration date. And, if I remember correctly, the statute said every violation of the law was an automatic $1,000 penalty. All right. So, like, imagine a gas station prints tens of thousands of these receipts a day. They have credit card or expiration date on there, not the number. It's harming no one. Like, there's no way you can do identity theft if you just have the credit card's expiration date. Card number's not on there, but it's $1,000 violation for every single one of the receipts the gas station printed that day. Over the course of the month, year, you're talking hundreds of millions, billions in exposure for something that's not hurting anyone. And so that was, a quintessential example of a no injury case, where we try to argue, the legal hook we used was there's no Article 3 standing for that. To have Article 3 standing to be able to bring a case in federal court, you need an actual injury. We argue these aren't actual injuries, these are no injury cases. And so ultimately, we had a case for a company called Spokio, that, I remember when I interviewed with those guys we were pitching for the case, I told them their case might go to the U.S. Supreme Court, because it presented one of these kinds of no injury type issues. And, very fortuitously and luckily, it ended up going to the U.S. Supreme Court.
Yeah, and so what was the outcome after the Supreme Court?
Yeah, so the fascinating kind of like turn of events, the Supreme Court ended up ruling for us, and it definitely made it much, much harder to bring those kinds of no injury class action cases.
Okay. You mentioned arbitration, which always here in California in particular seems to be a live issue. Is there anything you're watching for right now? I mean, obviously, I think when the current administration came in, there was sort of some rumblings that it might be a more favorable sort of policy landscape for defense. But is there anything you're sort of keeping your eye on right now? Any live issues that you're watching?
Yeah, I mean, I think the biggest live issue that I keep my eye on, obviously, there's all sorts of legislative, initiatives on arbitration issues. Um, at least at the federal level, they have a lot of them haven't gotten a lot of traction. But what I keep my eye on are this mass arbitration movement. I think it's fair to say that the plaintiffs' lawyers, who are up against, as I mentioned, the arbitration provision that says, hey, you can't bring this case as a class action. You have to bring it as an individual arbitration. I think one of the responses of the plaintiffs' bar has been to, okay, well, let's just file 1,000, 10,000 arbitrations, and see how the companies deal with those. And so that's always something that's kind of evolving. I'm not directly involved in those efforts, but it's something I for sure keep my eye on.
Right. And talking about current events, we've spoken a bit about your past. I'm wondering what are the current sort of main sort of industry areas you're dealing with, and um, yeah, what are the current issues coming across your desk as part of your current practice?
Sure. So it's interesting because, do a lot of tech work. I mentioned the Spokio case. Spokio is a technology company. We had done work for a number of other, pretty big high profile tech companies, Google, Facebook, eBay. But one of the more interesting trends that I've been fortunate to be a part of is, as let's call them brick and mortar companies start integrating technology into their products, they've started looking for, for lack of a better term, they're more open to hire tech lawyers, for lack of a better term, than, their traditional counsel. So think of, one of the bigger trials we had in the past like 5 or so years. It's a trial for the trade association for the auto industry. Massachusetts had passed a law requiring car companies to share the data coming off their cars or that their cars collect, and share it wirelessly. Well, from the car company's perspective, that created all sorts of cybersecurity risk and concerns. Um, and so, that was an instance of the car industry kind of facing a really technological issue. And so we were fortunate to be selected as the lawyers to handle that and, kind of litigate the case and try to educate, the judge and the court about how cybersecurity works on modern automobiles.
And what was the outcome of that case?
So we tried the case right through COVID. So I think if I have it right, it was like about 2021. We were in the midst of COVID. We tried it. Case then sat while the trial judge kind of considered the ruling. It got assigned to another judge. Eventually, that judge found that the law was not preempted, and that was our main argument that we said the Federal Motor Vehicle Safety Act preempts it, and that case is now still pending. It's up on appeal, and the parties are briefing that particular issue right now.
Mm. And you're still on the case, or
Yeah,
yeah?
yeah,
Um, I'm curious. We can talk more about what you're currently working on, but it's a good segue. Some of these issues, like technology wise, are incredibly complicated and layered. And I'm just wondering how how do you keep abreast of everything that's going on? And when you're tackling a case like the one you've just spoken about, how do you go about researching and getting um, up to date with the technology to a point where you can confidently sort of talk in court about it? Or do you like how much knowledge do you need to do that and to do your part of that job properly?
yeah. I mean, you do need that knowledge. There's no question about it. And you gotta love what you do because you've got to throw yourself in it. The only way, I'm a big believer in, the only way I'm going to be able to explain this to a judge or to a jury is I better really, really understand it at a deep level. And not only that, I need to be able to articulate it in a way that resonates with that judge or that jury who hasn't put in the hours figuring out what I've been able to figure out. And the way I do it is I read a lot about, the technology or the cases and industry magazines, whatever I can get my hands on. Obviously, spend a lot of time in that case. We spent a lot of time with expert witnesses and witnesses who worked at the car companies. I mean, just hours on end, asking them to explain to us how it works, showing us how it worked. They were so gracious with their time. We got to ask thousands and thousands of questions, and, after you put in the time and the legwork, eventually you kind of get a little bit conversant in it and you talk the language. And, we would ask them, interrupt us when we get it wrong. We need to make sure we get it right. But it's just, you got to dive into it. And that's why I say, like, you've got to love what you do because if you don't, it's going to be just a slog.
Yeah, does that mean your sort of Sunday afternoons are spent reading some sort of a technical manual?
Exactly, exactly. It's, looking up, YouTube videos, anything we could get our hands on to see, what way could we explain this more readily to the audience we needed to explain.
All right. Is there any, before we sort of press on to the leadership part, is there anything else you wanted to talk about in terms of your current practice, in terms of the cases that you're dealing with?
Many years ago, we were fortunate enough to be retained actually by the government of Brazil to represent the country in its quest to obtain the Bahia Emerald or get it back. It was the Bahia Emerald. If you don't know, it's like a 700-pound emerald, largest emerald in the world that was illegally smuggled out of Brazil. And it found its way to the United States. And then through a bunch of really weird transactions, it ended up the subject of a trial in Southern California and Los Angeles. And that trial made the news, and Brazil learned about the case, and they sent out, a letter to law firms. I still don't really know how they picked the law firms they sent it. But the letter literally said something like, "We lost a 700-pound emerald and we want it back. If you're interested in pitching for this case, let us know." And I did exactly what you was do when you got the letter. I threw it away because I thought it was a total hoax. I thought it was a scam. But the letter was also copied to the then managing partner of LA at the time, and he called me a week later, and he said, "Hey, did you get this letter? Are you going to respond to it?" And I was like, "Listen, this is a hoax. Like, they want our money. Like, I'm not going to respond to it." You see, yeah, you're probably right, but do me a favor, just check it out. We had literally just merged with Brazilian law firm, Toll and Checker. So we had just, all of a sudden hundreds of lawyers down in Brazil. So he said, check it out with them, verify it's fake. And so I did, and I was just stunned that it was real. It was a real letter from the Attorney General's office of Brazil. And so I flew down there, met with them, and ultimately we were retained. And it has nothing to do with my practice area or I think anyone else's practice area. It has more to do with like Indiana Jones's practice area. But it's been a pretty cool case to work on.
Yeah, where is the case now? What's happening?
So about a year ago, the federal court in Washington, D.C. ruled that essentially that the Bahia should be repatriated and sent back to Brazil. So we're literally going through. There's a treaty between Brazil and the United States that has a particular protocol that has to be gone through, and we're in the midst of that protocol. And so we're hopeful here in a matter of weeks, maybe months, the Bahia will be on a plane back to Brazil. So fingers crossed on that.
Yeah, that's great. I'm curious. You mentioned it's kind of not exactly in your regular wheelhouse. How did you win that pitch? Like how did you convince the government of Brazil that they should trust your firm with this case?
When this is all said and done, I'll ask them that point blank. My Here's my hunch. I don't know. My hunch is the strategy we set forth required us to first of all, deal with the Los Angeles court because there was a trial going on over people saying that the California court should award them the emerald. We also needed to deal with the federal government because Brazil is a foreign sovereign, and the natural it's going to deal with the federal government of the United States of America. And we had a really strong DC practice that dealt with this precise treaty, and so I think that probably resonated with Brazil, and we had offices in both places, experience in the treaty that needed to be invoked. So I think that's why they went with us.
I wanted to move on to leadership, and I sort of wanted to ask firstly, how long have you been managing partner?
Cool. Um, I'm gonna say I think I'm probably in my third or fourth year as managing partner of the Los Angeles office.
And for you, I know for a lot of people in leadership positions, it's kind of something they always wanted in some way or another. Was that something when you set out, when you graduated and went into the firm, did you have long-term aspirations to leadership? And what were those designs?
Yes and no. Did, but maybe not for the exact reason you would think. I wanted a leadership position, believe it or not, to bring some balance to the practice of law. I mean, look, I love my cases. I love working on them. I give them 1,010%, dive all the way in. Everyone needs a break. Everyone needs to pivot at some point. And it was always helpful, I found in my career, to have a management role that, if I needed to take a break from thinking about a case for, a half hour, an hour, it was always great to be like, okay, let me set this aside. Let me focus on some other issue to better the firm and to work on that. And so that has always been a really, really important part of of what I've wanted to do at Bayer.
Yeah, and you touch on an interesting point, which is how do you segment like that? Like obviously you're working on trials, you're working on cases, and you also have this management role. Is that a daily, like you said, I'm going to spend 30 minutes on this, I'm going to block my calendar for this, and do you take it by a weekly, monthly kind of time blocking situation, or how do you approach those dual roles?
Yeah, I wish I could be that, diligent. Here's what helps though. There's three factors that help. I wake up crazy early. I live far away from the office and I don't like traffic. So what that means is I wake up crazy early. I get into the office pretty early and it's very quiet and I'm on the West Coast, right? And so what that lets me do is I try to attend to my management obligations best I can in those first few hours at my desk where it's quiet, get that out of my way. And then when people start, coming through the halls, the phone starts ringing, the emails start coming in on West Coast time. I'm in, it's the start of the business day. So I feel like that's kind of been a de facto way for me to balance those two aspects.
And if you were, this is a really hard question, but if you were to put a percentage on how much of your role is management, how much of your role is attorney, what would the split be?
I would say it's like 90% attorney, 10% management. Yeah, for sure.
You said sort of 3 or 4 years as managing partner. What were the biggest initial, I want to say shocks that came with the role, but like what sort of transition kind of items did you have to deal with where you were like, okay, this is what it's like. This
Yeah,
is
well,
this is how it's going to be.
yeah. So no doubt this was, drinking from the proverbial fire hose. So when I took over as managing partner, it was kind of at the tail end of COVID. We're coming out of COVID. People were starting to return to the office, but there were no anchor days or mandatory days. All that was still very fluid. But I met with the then managing partner, and he said, "Okay, well, guess what? Our lease is up, and your first thing you got to figure out is what are we going to do?" And that was a daunting task because we had been in the building we are occupying at the time for, gosh, I think over 25 years. It was like the only home people knew. Uh, it was probably needed some renovation. It was trying to figure out, should we stay? Should we go? If we go, where do we go? If we go, do we rent someone else's space or do we build our own? It was a lot. It was a lot. One of the things I've always kind of done in my role is like to consider myself as building teams. And I was a basketball player growing up, so I always look at things as a team mentality. One of the things is when you start consulting a lot of people about all those issues, like you get a lot of views and a lot of opinions, and a lot of them pretty, heartfelt opinions. So just navigating all that was really really challenging at times because we were trying to make some really important decisions about, our office and our firm. And I was like brand new at the job, and I knew people were like, "What's this guy going to do? How's he going to do it? How's he going to work?" I like to think we got to an amazing place, but it definitely had its.
Yeah. And so what did you end up doing? What does the office look like now compared to what it was before?
I mean, night and day different. I think we have the nicest office space in America. I really do for a law firm. I would love to invite you in to check it out. You can tell me if I'm wrong. We decided to move and we decided to basically build from the ground up. And I remember challenging our architect and saying, listen, there's a lot of talk and a lot being written in the industry about returning to the office. I want you to make it easy for me. I want you to make the office a special place where people want to go and want to be a part of. And we focused in particular on our conference room space. We made it, everyone at the time, like, well, when we come back to the office, it's to see our team members and we want to collaborate. So we really emphasize making kind of collaboration spaces, different conference rooms that have different feels, different vibes to them. Some very formal, as you would expect in a law firm, a lot that are much more relaxed environments. So it was kind of neat to work, in that era and try to work through some of those issues at a time when, our landlord was terrific and really worked with us to make this all, affordable. It was a good result. Really proud of it.
The thing that sort of strikes me when I visit a lot of firms, we talk to a lot of different folks. Obviously, COVID was huge, and the changes it made to work patterns were huge. And I feel like sort of young associates are probably the class that have been hit the most, recent grads. How are you handling sort of, I guess, associate mentorship, career development? Do you guys have mandatory attendance? Is there an overall strategy you have for really kind of mentoring that next group of leaders within the firm?
Yeah. So we do, as a firm, we have a policy of being in 3 days a week. We have anchor days, which are Tuesday, Wednesday, Thursday, where, we basically told our folks we would expect to see you guys there. That's terrific from their perspective. They want to work from home on Friday and Monday and have a 4 day off. That's fine. What we've seen is more and more people are starting to like kind of return even beyond that. What I think one of the really important things I've worked on is and recognized is one of the things that happened to all of us during COVID was we had autonomy, right? As people were returning to the office, we kind of were able to return almost on, a needed basis as far as, how I needed to do it, how other people to do it. We were very respectful of people returning to the office. And then obviously the world evolved and more companies and firms were like, okay, well, we need to have procedures, policies around it. And, that's where we are now. But, I think it's still important to respect that autonomy that people develop. And so we always work with our folks, if they say, look, I can't make it on Tuesday, I have a handyman, but like, can I substitute the Monday instead of we're always going to work with, our people to do that. So I think that's been, part of it. Was challenging during the pandemic when everyone was on Zoom. And, that's why I mentioned the collaboration spaces that we were trying to develop when we were building out the office. That's exactly why, because we recognized the one thing that really took a hit during the pandemic was that in-person mentoring. We wanted to make sure we created a venue to allow that to happen. That's critical for, the practice of law. It is by far the way associates learn the most is just through hands-on experience and being able to go down the hall, talk to someone and say, hey, I'm facing this in a case. This is challenging. How do I do it? If you faced this before, and just having that interaction or the informal conversation, it was for sure possible during COVID on a Zoom, but it just realistically, it was much harder to do, and it wasn't happening at the level it needed to be happening. So hopefully that did I answer your question.
Yeah, no, that's great. I'm wondering also, given your leadership journey, did you have a particular mentor, a set of people who really assisted your career? And was that a conscious decision on your behalf, or is it just something that sort of serendipitously happened?
It was something that serendipitously happened. It was the partner. She's actually a judge now, Teresa Bouvet. It was a partner that I ended up working with most on my class action cases, kind of in that, as I mentioned, in that era where I transitioned to class action defense. She was handling a lot of the wage hour class action, so I got to work with her. And it was that, that's why I'm such a big believer in the mentoring. That's how I learned. It wasn't that like, she sat me down and like, hey, John, this is how you write, or this is how you. I got to see her doing it. I got to see her working. I got that interpersonal connection, being able to see her in action and learn from that. So she was definitely one of my mentors. All the partners that were here at the time, I learned very, very valuable lessons from, but she for sure sticks out. And that's what, now in my role as managing partner, I want to make sure we replicate that and give our younger associates that, that same opportunity to learn, an apprentice style profession.
That's great. All right, John, that's pretty much it for my questions, but I wanted to give you, I have one more question afterwards, but if there's anything else on the leadership piece you wanted to address, this is your chance.
All right. So, one of the things I've always tried to do through management and also on my litigation team is to empower the folks supporting the team, whether it's on one of my cases, empower the junior partner on the case, make sure that he or she has full client access, can interact directly with the client, can cover hearings, do their own, a lot of their own writing, their own arguing. That's always been really important and valuable to me. And one of the lessons I've learned is that when you do that, you've got to be okay with them doing it differently than you. And doing it differently is fine. If they're doing it incorrectly, it might be probably good to, have a chat about it. But not micromanaging their own development into the own type of litigator that they're going to be, I think is something that is really, really important for leaders to do, either on pieces of litigation, and the same is true in management. You got to deputize your folks that help you manage, an office like the LA office. And then you got to trust them to do their thing. And you got to be okay with the fact that they're going to do it different. It might be better, and that's okay.
Great advice. All right, thanks, John. My last question, you may or may not have an answer, because I find when I ask attorneys, they're like, no way, I'm way too busy reading for my cases. But is there a book, a podcast, some other form of media you have consumed in the last year that you've either found like really helpful for your professional career, or you've just enjoyed and has just been an enjoyable thing to consume that you'd recommend others to also listen or read to?
Yes, there's definitely one book that has impacted me a lot, especially recently. It's this book by the president of Northeastern University, believe it or not, President Aoun. And he wrote a book some years ago called Robot. And this is part of the educational philosophy of Northeastern University. It's also the university where my oldest daughter happened to go. So that's how I'm intimately familiar with this book. But its lesson is, and their educational philosophy at Northeastern is, they need to educate a workforce that can learn how to work alongside of technology in the future, to know what technology is good at and what technology should do first and foremost, but also what's the technology weakness and where can humans fill in that void. And obviously that is front and center of the discussions I think every law firm's having around AI. And so that has been a book that has really kind of stuck with me. I first read it, I want to say 5, 6 years ago, but it's even more relevant today.
Great. We're always after book recommendations. I'd love to start an attorney's book club. So that's great, John. That's it for my questions. Thank you so much for joining us, John. It's been a great conversation and really appreciate it.
My pleasure. Thanks so much, Jack.
That's it for this episode of In the Counsel's Chair. We hope you've enjoyed it. Please do be sure to give the show a follow on Apple Podcasts, Spotify, or wherever you get your podcasts. That way, you'll never miss an episode. If you're looking for more content about California's legal sector, head to dailyjournal.com. If you're not already a subscriber, you'll find details on how to subscribe on the website. We'll be back next week with another episode. I'll see you then.